Good evening. I'm Mark Tushnet, professor of law at Harvard Law School, and I'm pleased to be joining you virtually this evening as part of the American Repertory Theater's 1776 Salon series. Thank you for tuning in. We'll have time for a question and answer at the conclusion of my remarks. Please feel free to submit questions using the YouTube chat section to the right of your screen. My topic tonight is ancestor worship in our thinking about the Constitution. And I suppose I should begin by saying that I'll be talking about the Constitution, which was adopted in 1789, and so not really about 1776, although towards the end of my talk, I will come back to talking about some aspects of the Declaration of Independence. I begin by quoting a letter that Thomas Jefferson wrote to an acquaintance in 1816. And this is what Jefferson said. Some men look at constitutions with sanctimonious reverence and deem them like the Ark of the Covenant, too sacred to be touched. They ascribe to the men of the preceding age a wisdom more than human, and suppose what they did to be beyond amendment. I knew that age well. I belonged to it and labored with it. It deserved well of its country. It was very like the present, but without the experience of the present. And 40 years of experience in government is worth a century of book reading. And this, they would say themselves, were they to rise from the dead. Now, before launching into a discussion of the significance of this statement, I want to pause to note something about Jefferson as an author or as a writer here. When I present this letter to my students in class, I say, now, think about, I put it this way, this letter is, I say, better written and more eloquent than the best thing that President Trump's best speechwriter or President Obama's best speechwriter could produce, much less President Trump or President Obama themselves. And so the quality of what Jefferson has to say sort of puts presumptively in front of us the idea that actually these people should be treated with some degree of reverence, perhaps not sanctimonious reverence, but reverence. Now, Jefferson was writing about why people should be willing to amend the Constitution when experience showed its flaws. And I want to contrast what Jefferson said with something James Madison said on, roughly speaking, the same topic when the adoption of the Constitution was being considered. So Madison wrote about why, as he put it, frequent appeals to the people, either to amend the Constitution or, more interestingly, to generate a public constitutional critique of something that the national government was doing. Here's what Madison said. Frequent appeals would, in a great measure, deprive the government of that veneration which time bestows on everything. Now, note the attitude here is similar to, but not exactly the same as the attitude of reverence towards the men of the preceding age that Jefferson was referring to. Madison talks of veneration of government, not necessarily of the founders. We can question that sort of veneration of government as well, but that's not my topic. And neither are the founders' imperfections as people. They were, of course, imperfect. The most dramatic phenomenon is, of course, the fact that they were, many of them, owners of enslaved people. They did not always have impeccable private lives. So these are not people who were beyond flaws in their lives, but the attitude that Jefferson described was not about their personal lives. It was about their an attitude of veneration or of reverence with respect to the founders in their capacity as makers of the Constitution. Now, as you all probably know, the attitude Jefferson described is with us today. So in a speech to the Federalist Society, Justice Neil Gorsuch said that his confirmation of the court showed that a person can be both a publicly committed originalist and textualist and be confirmed to the Supreme Court. And the recent impeachment proceedings placed the framers' understanding of the term high crimes and misdemeanors at the center of the legal presentations to the Senate. Now, I'm going to examine several aspects of the attitude of reverence and veneration that Jefferson and Madison described. In my opening presentation, I'm not going to talk in detail, maybe even at all, about originalism as a mode of constitutional interpretation, although I'm happy to take that up in the question and answer period. My first topic then is going to be the phenomenon that Jefferson described, the failure to shape our understanding of what a good constitution should look like in light of what is now more than 200 years of experience. And my example is the way we choose our president. Now, the framers faced a choice. Some vigorously advocated for direct election by the people, what we would now describe as election by a popular national majority or plurality. And they did so on the grounds of, call it democratic theory. This was to be a government of the people of the United States, and the people of the United States should, in our sort of collective capacity, choose the president. The people who supported indirect election, eventually embodied in the Electoral College, prevailed. And I want to talk about one particular argument the advocates for indirect election made. In this argument, they were concerned about voter knowledge in the social circumstances of the late 18th century and in the anticipated 19th century. So, for example, one participant at the Constitutional Convention worried about how much a farmer in backwood Georgia could know about all the potential candidates for the presidency. Some from places as far away as Massachusetts, months of travel away. And it's noteworthy, of course, at this time, there were very few newspapers. The newspapers that existed were confined to local topics. And so the concern was, if you have a national direct election, what will the people know about the candidates they are choosing? Now, what's interesting here is that those making that argument knew that circumstances might change. So Abraham Baldwin of Georgia said, the increasing intercourse among the people of the states would render important characters less and less unknown. And James Wilson of Pennsylvania echoed that. Continental characters will multiply as we more and more coalesce. So as the nation grew as economic exchange, that is, increasing intercourse among the people of the states, as economic exchange knitted the nation more closely together, as the nation more and more coalesced, the knowledge that local people would have, people in their localities would have, of these national figures would increase. Now, Baldwin and Wilson didn't draw the inference, they didn't have to, that maybe once that happened, it might make sense to switch from indirect election to direct election. But we could think about that as a possibility that's faithful to some extent to the constitutional design that the founders had. I want to note one point in passing before returning to the main argument here. In fact, the founders' generation rapidly discovered that they had designed the mechanism for the selection of the president badly. The way it was designed at first was through this indirect election mechanism. The electors would cast their votes for two people. And then you would add up the votes, and the one who had the most votes would become president, and the one who had the next most votes would become vice president. Well, in the election of 1800, that system collapsed for reasons that are significant much more broadly. Two national political parties had come on the scene, and they ran tickets of a president and a vice president. And the Jeffersonian Party, their electors cast their votes, their two votes, for Jefferson and Aaron Burr, the vice presidential candidate. And the Federalists cast their votes for John Adams and his vice presidential candidate, except that one of them figured out that this was not a good idea and voted for somebody else for vice president, cast the second vote for somebody else. So in the end, the two candidates who had the most votes were Jefferson and Aaron Burr. And then, an incredibly complicated story developed. In the end, the election goes to the House of Representatives. That's part of the initial design. A Federalist, that is an anti-Jeffersonian, behaves like a statesperson and casts his vote for Jefferson, and everything works out fine. The popular vote winner becomes president. And then they amend the Constitution to get rid of this problem. Now the electors cast their votes for a president and a vice president. Okay. Now, that's an interesting sidelight on the general story, which is, again, Jefferson was writing about viewing the Constitution as if it were the Ark of the Covenant, nothing, so that it couldn't be touched. But here he said, basically, he knew that they had made some mistakes. And that mistake emerged within 10 years. He said 40 years of experience is more than book learning. Maybe we should learn from that 40 years of experience, or now 200 years of experience, and rethink some of the aspects of our constitutional design. Okay, now I want to go back to what I quoted from Baldwin and James Wilson. So Baldwin says, would render important characters less and less unknown. And James Wilson said, continental characters will multiply. And here, I want to say character means roughly what we mean by it today. The image then would be of George Washington. The image today, or 50 years ago, might be Dwight Eisenhower. A person, through his or her contribution to governing ourselves, demonstrated the civic virtues necessary in a president. And again, as these important or continental characters became more widely known, it might be appropriate to move from an indirect election system to a more direct elected system. They understood that circumstances would change in ways that might support replacing indirect with direct elections, but they didn't anticipate that social change would make it possible for people to become known nationally for reasons other than their demonstrated civic virtue. That is, people might learn about, people in localities might learn about lots of people around the country, but not because they were continental or important characters. So the examples I use actually don't involve candidates for the presidency, but they involve, in the first cut, sports figures who become members of Congress. And then the second cut is an example of an entertainment figure who became a member of Congress. So Jim Bunning, a great pitcher, became a member of Congress, and Bill Bradley, a great basketball player, became a senator. And this one, I had to look this one up because I misremembered who it was. Fred Grandy, who was on the Love Boat, became a member of Congress from Iowa. And you know, actually all three of them were basically fine legislators, but they didn't become known to their constituents by performing, by being an important or a continental character, by demonstrating their ability to govern well at lower levels. Okay, so there's an example of a situation where the framers sort of understood that social change might make a difference with respect to direct election. They designed things for the world they knew. Maybe the world would change, but actually, although they thought the world might change, they didn't quite get it right about what the change would be. And that poses interesting questions for us about how we should deal with their design. So my second example is impeachment. Impeachment was designed in and for a world without political parties organized on a national scale. And one way you can see that actually is by the provision that I already referred to, the one that was eliminated by the 12th Amendment, where the winner would be the one with the greatest number of national votes, and the vice president would be the person with the second number. So that's sort of like that in 2008, Barack Obama would become president, and John McCain would become vice president. And that's weird today, but that's what they thought. And they thought that was sensible because you would have these two people, each of whom was a continental character who had demonstrated civic virtue and was supported by a lot of people in the country. And they were both going to be interested in promoting the civic good. Now, they would disagree about what the civic good would be, but their goal was to make the nation, to move the nation forward. Okay. Well, that was the design at the time, but once nationally organized political parties come onto the scene, we have to change the way we think about things. So with respect to impeachment, to perform the function it was designed for, impeachment, necessarily a process shaped by the Constitution, has to be shaped by experience as well. Now, how did the framers, the founding generation, think about impeachment in the terms relevant here? Well, James Madison had this idea that we could deal with problems of a president gone wrong through the separation of powers. And he used the line in one of the Federalist Papers that the interests of the man should be connected to the interests of the place. Now, what did he mean by that? So here's an example, now obvious from recent experience. Suppose you have a president who many members of Congress, it really doesn't matter how many, but many members of Congress think has misbehaved, has not served the nation well. And they want to find out what's actually happened. So they ask for information from the president about this problem that they're worried about. Could be lots of things. It could be the Watergate break-in. It could be policy misadventures with creating a healthcare system. Doesn't really matter. They just ask for information. And the president says no. Okay. Now, Madison's thought, the interests of the man should be connected to the interests of the place, was that when the president said no, members of Congress would say, wait a minute, we are members of Congress. We have our own interests in finding this stuff out. You have your interest in keeping it secret. We understand that. But we have an interest in doing our job. And so, pursuing the interests of the place, they would fight against the president. Okay, so that's the theory, and it's not a bad theory, actually. The problem is that it doesn't work well when you have organized political parties on a national scale. Now, actually, all of the parts of that are significant, organized parties and on a national scale. Now, the framers knew about the possibility of parties. They called them factions, and they didn't like them. And Madison, again, sort of had a theory about how we could prevent the rise, actually, how we could keep factions under control. He said there's no way of eliminating factions, but what we can do is design a government in a way that reduces their ability to cause problems. And his answer was our system of federalism. So his notion was you'd have a national government that would do what he called have few and defined powers, do important national things, but you'd have state governments that were doing the things that mattered most to most people in their daily lives. That latter would mean, yes, you would have factions, but they would be organized on the local level to deal with the things that people cared about. You know, contemporary issues would be things like road repair or school education policy. In my own experience, my experience of this is reading the things that are raised as significant on my neighborhood listserv and how it communicates to our member of the city council. Okay, that's the kind of stuff that people actually do care about, and again, political parties, factions would arise around them, but they'd be local in character. The issues that mattered in Newton might not be the issues that matter in Somerville, much less the issues that matter in Montana. And so you couldn't have, there might be a Massachusetts party, but it wouldn't be doing things similar to what the Montana party would be doing. Okay, fair enough. That's a decent theory. The problem is it's undermined by economic growth. Again, the things that Baldwin and Wilson referred to, the coalescence of the nation, because that growth led to interconnections among the country. And actually the framers understood that that was going to happen. They gave the national government the power to regulate commerce among the several states. Okay, there's a long story to tell here, and I'm not going to tell the whole story, but the basic story is that if you're going to give Congress the power to regulate commerce among the several states, and you're still going to want to have these local governments doing important things, you're going to have to come up with some doctrine that's going to describe things that were, as John Marshall once called them, wholly internal to a state that didn't affect other states. And with economic growth, that turned out to be impossible. And once that happens, factions will organize on a national scale so as to promote the things that are common among people among of the several states. So the sort of obvious example these days are environmental issues. But there's an interesting problem that we are now facing, which I'll just pose. I think the answer is going to be clear, but how we explain it is harder in the framers' understanding. Could Congress today pass a statute that said in any state where there are 75 detected cases of coronavirus, the following steps of quarantine and so on must be taken? Or alternatively, could Congress say, once the national figure for detected cases reaches, 10,000, here are the quarantine and other precautionary things that will kick in? There's actually a genuine question under existing constitutional law about at least the first of those, and maybe both of them. And yet it's sort of clear that the answer should be yes. And so if we have a design that says, well, maybe it's not, something's gone wrong. Okay. So now back to the story about parties. Once you get economic growth, you're going to get national parties. Now, it turned out that it took a long time for things to develop. First of all, there were national parties that were loose coalitions of locally organized parties. So again, the parties were organized locally. There were particular issues on which they saw common ground with people elsewhere. And so with respect to those issues, they would form larger parties. But the issues, these alliances, these parties were quite loose. And they had factions within them, which made it possible for some things to be done across party lines. Again, the standard example I use in teaching refers to the middle of the 20th century, mid to the late 20th century. There were Northeastern cosmopolitan internationalist Republicans and Western conservative Republicans, and liberal Northern urban Democrats and conservative Southern Democrats. And so you could have, again, sort of cross-party interactions, which allowed for the separation of powers idea to have some force. It's not that the interests of the man were connected to the interests of the place. It's that the interests of the members of the House and Senate were connected to not their own parties, and in particular, not necessarily to the party of the president of their own party, but to this broader, fluid, more looser coalition. Then the parties became increasingly coherent internally. There's a lot of discussion in political science and constitutional law about why it happened, but for our purposes, the why doesn't matter. That it happened is the significant feature. There are now, for all practical purposes, no Northeastern Republicans left, and there are no conservative Southern Democrats left. The parties became programmatic, ideologically coherent, rather than factionalized. And the odds of a member of a party in the Congress opposing the president of his or her own party is close to zero. In the House, in the recent impeachment, it was zero. In the Senate, it was 1 out of 53 with Senator Romney. So now, I have to say, given this party polarization, under some arrays of power, as we saw in the recent impeachment, impeachment is workable in some sense in the House if the House majority party is different from the president's majority party. We actually saw that in the Clinton impeachment as well. But as we saw in both of those impeachments, it's not workable in the Senate because, as we know from recent experience, removal from office requires a supermajority in the Senate, 2/3 of the Senate. And under modern circumstances, it's inconceivable that a president would not have the support of at least 1/3 of the Senate. I also note here that workability is a tricky concept because we also have to worry about merely partisan impeachments. And one consequence of the recent events has been the suggestion that impeachment may now be a more regular tool in the sort of separation of powers battle. So just to conclude, one way of this discussion, one way of understanding the situation with respect to impeachment is captured in the title of one of the most important articles on constitutional law recently written. We have, as the article title puts it, a separation of parties, not a separation of powers. And that has broad implications for the way the government works. And now, to go back to the original theme, since they didn't anticipate this kind of development, we ought to be willing to rethink the kinds of design that we might want to use. Here, I want to quote Lincoln, as our case is new, so we must think anew and act anew. We must disenthrall ourselves, and then we shall save our country. Lincoln was writing about the constitutional dimensions of the conflict that produced the Civil War. We need to think anew. Exactly what that means is hard. We can think about amending the Constitution. That's really difficult to do formally, but maybe there are ways of doing it informally. Or, and this leads to my next topic, maybe we as a society ought to, as I put it, de-legalize our thinking about some of our constitutional aspects of our constitutional design, such as impeachment. And so I want to take that up. The next topic is what I call the professionalization of constitutional discourse. And the impeachment's my example. When members of Congress wanted to know how to interpret the impeachment clauses, they turned to lawyers. 3, I guess it was, in the Senate, House, I forget now. But even though, in my view, historians, political scientists, political philosophers, maybe even theologians might have offered different and sometimes better, perhaps, insights. The substantial loss of so this professionalization reflects or is also embodied in the loss of a tradition of popular constitutionalism in which ordinary people offered and it actually eventually made into lawyers' law their interpretations of the Constitution. I should give a couple of examples of that. In popular constitutionalism in U.S. history, there was a strand in abolitionist thought, abolition of slavery, which argued quite eccentrically from the lawyer's point of view that the existing Constitution didn't tolerate slavery. This was offered as a way of understanding the Constitution that we had. In the late 19th and early 20th century, labor unions said that our Constitution protects, through the protection of free expression, our right to organize and engage in strikes. Every lawyer in that period said no, it didn't. Every case rejected it. But the labor union organizers made a constitutional argument about their power, their entitlement under the Constitution to organize and strike. And a slightly different version of this, but still significant, in the 1940s, Franklin Delano Roosevelt gave this famous speech on the four freedoms. And the four freedoms were about freedom from want and freedom from fear, what we would now call economic rights, social welfare rights, right to health care. The professionalization of constitutional discourse pushes those ways of thinking to the margins. And it might be valuable to try to retrieve the tradition of popular constitutionalism, which again is people today saying what the Constitution means. So again, it's not revering the framers and the Ark of the Covenant and all that sort of stuff. It's saying they created a constitution that they understood to be good for them. We today can ourselves create a constitution that's good for us without going through the Constitutional Convention amending process and so on. And now finally, I want to tie this back to 1776. And here the way to do it is to note that as a matter of professionalized law, the Declaration of Independence has basically been erased from constitutional law. That is, it is not treated as having any legal significance for interpreting the Constitution. I should qualify that in two ways. First, there is a tradition, a school of interpretation, often associated with a group of conservatives who argue that the Constitution should be interpreted in light of the Declaration. And there's this very nice quotation again from Lincoln, who says that the Constitution is the frame of silver around the apple of gold. The apple of gold is the Declaration of Independence, and the Constitution, the frame, is how we try to implement the Declaration of Independence. Clarence Thomas has gone along with the idea of the Declaration being significant once or twice, but more often the Declaration is treated like the Constitution's preamble, a description of the general aims of government that has no legally operative force. And so we have a sort of a constitutional ancestor worship, not an ancestor worship of the founding era as a whole. Now, maybe we can explain this by returning to James. Sorry, I've lost my notes here, so I'll have to. Okay. Returning to James Madison on venerating the government. Maybe venerating the government doesn't mean venerating the Constitution, and certainly not the actual human beings who were the founders. What we might do is say, look, they created a government that worked for their time, didn't work very well in the Civil War period. We reconstructed it. We can reconstruct our government again. As Lincoln said, as the times are new, we should think anew. I want to we'll all disagree about exactly what we should do about that. I guess I have to advertise here something. I have a book coming out in May called Taking Back the Constitution, which ends with a discussion of things we might do to take back the Constitution. And I would be happy if all of you purchased a copy when it comes out. I do want to finish by noting a sort of peculiarity, which is that I've framed this discussion with references to and quotations from Thomas Jefferson and James Madison and Abraham Lincoln. And so you might ask, well, aren't I just reproducing the kind of ancestor worship that I'm trying to challenge? And the answer is, I don't think so, because my position is not that we should venerate them, in Madison's terms, or treat them with a reverence that we would associate with the Ark of the Covenant, but rather to go with Jefferson himself. I knew that age well. I belonged to it and labored with it. It deserved well of its country. Okay, these were people who were serious people thinking seriously about how to design a constitution. And we ought to respect them for that. Now, the shorthand version is James Madison was a smart guy, and we ought to pay attention to the things he worried about. But he wasn't dealing with the problems of the 21st century. And again, I'll finish with this, the Jefferson quotation. His last line is, 40 years, now 200 years of experience in government is worth a century of book reading. And this they would say themselves, were they to rise from the grave, from the dead. That's the attitude, I think, that would be helpful to have today. Okay, so now let's take some questions.
Thank you so much for joining us. That was incredible. So we've got a bunch of questions coming at us from some different platforms, and I'll start out with a fun one. Someone on Instagram wants to know what the best part of your job is.
So the best part of my job is actually teaching students. I really like talking with students. Figuring out how to engage students in a conversation about how we ought to run our government. I have my own views. I don't regard it as my job to persuade students that my views are the right ones. As I told my students earlier this year, occasionally I take on the role of browbeating them just so to, get them, to prod them into talking. But just having a conversation about how the government should work is really interesting and fun. And it's part of the idea that I talked about here of popular constitutionalism. I think we all ought to be having that kind of conversation, not just in classrooms dealing with constitutional law, but in coffee shops when we're talking about impeachment.
Wow, excellent. So from someone who's tuning into our YouTube stream right now, they say there are obviously a number of potentially very good changes to the Constitution we might think of. However, the very Constitution we'd like to amend makes it very difficult to do so, does it not?
So the answer is yes. The mechanisms for amending the Constitution are quite difficult to implement. I am among one of a very few number of people of my general political persuasion who thinks that it might not be a bad idea to have a new constitutional convention where we would sort of put the whole thing up for grabs. There are lots of problems with that that might arise. I deal with some of them in the book that I mentioned. But there are other ways of generating popular pressure for constitutional change, sometimes informal, sometimes within the bounds of what we already have. There are now lots of ways of doing deliberation among people, the conversations that I was talking about, through modern media. There are practices of deliberative polling. Several nations, Ireland and Iceland, have done constitutional revision through social media. They're very interesting stories. I think there's an opportunity to experiment with expanding the civic conversation through creative uses of social media. Now, I have to say, creative uses of social media, I don't mean Twitter conversations. Twitter conversations about the Constitution are very bad. But so there are design things that we have to work out. But I think there are options on the table to expand the discussion. And then once we start talking about them, politicians and creative lawyers may figure out ways of actually doing things without formally amending the Constitution.
Excellent. And I'm going to ask you if you wouldn't mind sort of recapping and repeating the
sorry.
question, just to make sure our viewers at home follow along. That having been said, this next one is a pretty lengthy question, so I'm happy to repeat if needed. The delegitimization of authoritative and reliable sources of information allows extreme tribalism to flourish. When this comes from the highest levels of government, how do the people fight back?
Okay, so this is a question about the modern media environment and how claims about facts become politically contested. The label is fake news, but and that has a particular political connotation these days. But the phenomenon of people disagreeing not merely about what a good policy would be, but rather what the facts are about which we have to make policy, that phenomenon is, from the point of view of an educator, extremely troubling. It used to be, I think, that there was general agreement on some broad kinds of facts. That always had an ideological spin to it. There was a sort of establishment version of the world that people came to understand, and dissidents would offer a different view of the world, but didn't seem to be quite as difficult, as problematic as it is now. This is not an area that I specialize in. I think I do teach free expression law and existing free expression law, and I think any sensible free expression law is going to have a lot of difficulty coming up with public grounds, enforceable grounds for dealing with claims about fake news. At some level, probably what we need is come to some extra legal cultural understanding of how we're supposed to deal with each other. But beyond that, I'm now at or beyond the limits of what my specialization allows me to say.
Great. I have a really fun one coming in from our YouTube. Why do you think 1776 is an important show right now?
Okay, so the question is, why is 1776 an important show right now? I think it's important, maybe not merely right now, but so my view is that the opening words of the Declaration of Independence and the political theory embodied in it is sort of, I don't know how to put this, a permanent contribution to human well-being. When in the course of human events and so on, and we were endowed by our Creator with inalienable rights, these are really important ideas for people to think about as we go about the job of, in part because of the Declaration of Independence, governing ourselves rather than being governed by other people. So at some level, anything that renews our appreciation for the thing that gets embodied in the Declaration is, I think, important.
Great. Would it be correct to say that you think Jefferson and Madison would strongly oppose an originalist view of constitutional interpretation?
Jefferson pretty clearly, yes. So the question is, would Jefferson and Madison impose an originalist view of the Constitution? I suppose I should preface this by saying that there are a lot of things that go under the heading of originalism. And so it's not entirely clear what you're talking about if you just talk about originalism. So let me say just two things to frame this. The first is that I don't know of anybody, including me, who wouldn't identify myself as an originalist, but I don't know of anybody who thinks that the things that the framers thought about, had in mind, what they wrote, is irrelevant to interpreting the Constitution we have. Okay, so everybody thinks that some aspect or some kind of originalism has some bearing on interpreting the Constitution. Second is that I think it's fair to say that, notwithstanding what Justice Gorsuch said, no judge is always and only an originalist. Justice Thomas comes closest to that, but there are times when even he acknowledges, or sometimes doesn't acknowledge, departing from original understandings of the Constitution. There are stories you can tell about why those departures are justified, but they are not originalist departures. Nobody thinks that originalism is irrelevant. No judge thinks that originalism is the only thing to do. I should say, finally, there are some constitutional scholars, theorists, who do say originalism is the only thing to do. But that's a position that is academic in the pejorative sense. It doesn't connect up with a real practice of constitutional interpretation. Okay, now having said that, what about Jefferson and Madison? Jefferson pretty clearly would not have paid much attention to the understandings circulating around the time of the framing if he thought that circumstances had changed. There's one qualification. He might have thought that 40 years of experience is more than book learning and all that sort of stuff, and we ought to amend the Constitution. So, and he did have this notion that the Constitution should last for, his line was 19 years, and then we should redo it every 19 years. So maybe he would have said, well, we got off track not by adopting originalism, but by abandoning the practice of amending the Constitution. Madison is a closer question. He first of all, he quite properly understood that he had done a really good job of designing the Constitution, that without being, self-centered or anything like that. He understood that he was a smart guy. He and so but he also had this notion of that he wrote about in the Federalist Papers of what he called liquidating constitutional meaning. So what he wrote was that many of the Constitution's provisions were unclear or open-ended. He was saying, we ourselves don't really understand what we're doing. We've sort of situated this problem in a general area, but over time, the meaning will be liquidated as people work with the provision in trying to govern the country. So he had an idea about how the Constitution would develop that wasn't tied tightly to original understandings, at least with respect to these provisions whose meaning was going to be liquidated over time. I should say my guess is that he would have thought, were he to be exhumed from the grave, he would have thought that these terms would be liquidated in like 50 or 60 years. We'd have a settled understanding. They wouldn't be open-ended to the current day. But I'm not sure that would have been a correct understanding of what liquidation really is.
And we've got another question from YouTube coming from a longtime ART supporter. Are there any countries whose constitutions have evolved over time in a way that you think the U.S. might benefit from replicating or drawing inspiration from when looking at our own path forward?
So the question is whether there are countries who have constitutions that have evolved over time in ways that are worth thinking about for the U.S. That's a very tricky question. And the reason it's tricky is that there are very few constitutions that have been in place long enough for us to observe real evolution. The U.S. Constitution is from 1789 with major amendments in the post-Civil War period. Even on that account, it's 150 years. After that, the major constitutions that are worth thinking about are things like the German Basic Law, which is from 1949, the Indian Constitution from 1949-1950, the Canadian Constitution/Charter, which is from 1982. Now, all of those have things in them that are worth thinking about in a variety of ways. The Canadian Charter has something that allows the legislature to override decisions of the Supreme Court if they think they're wrong. I think that's a very interesting and sort of attractive feature. The German Constitution has a constitutional commitment to social welfare rights. And the Indian Constitution has a similar commitment that the court has actually attempted to enforce. So there are things in other constitutions that are worth thinking about, but they're not examples of how people started at one place and ended up at another. Or maybe, now that I've said that, maybe we're in the middle of seeing things which scholars have started to call constitutional backsliding. People starting out with good constitutions and then gradually making them worse. That's certainly not something we want to emulate. But looking around for things that might be, were we to be able to redesign our Constitution, there are things around the world that are probably worth looking at.
Could you comment on the National Popular Vote Interstate Compact as a way around the Electoral College?
Okay, so the question is about the National Popular Vote Compact. That's a thing. I call it a thing for reasons I'll get to in just a moment, that operates in this way. Each state, well, state by state, legislatures enact a statute saying that we are instructing the electors in our state to cast their vote for the person who receives a majority or a plurality of the national popular vote, no matter who wins in our state. And so, but they say this is going to go into effect only when states with a total of 271, I guess it has to be 271 electoral votes, sign on to this thing. Now, if that works the way it's supposed to, you get the right number of states, and they automatically get 271 electoral votes for the winner of the national popular vote. Okay, it's a very clever thing. And I guess there are now like 30 or 40 votes, popular electoral votes, states with 30 or 40 electoral votes short of getting to the 270 or 271. I just would want to note a number of things about this. First of all, it's the proponents of it call it a compact. I think that may have been a strategic error because there's a provision in the Constitution that says Congress has to approve compacts among the states. Now, there's a jurisprudence associated with the compact clause, and maybe this thing doesn't count as a compact under the jurisprudence of the clause. I actually think the better reading of the cases is that this thing is actually not a compact within the meaning of the clause, but I think it's a close question. Second, there's now pending before the Supreme Court a case that asks whether a state's legislature can bind its electors to vote in one way or not. It's pretty clear from the story about the Electoral College that I told that at the outset, the electors were understood to be in a position to cast the votes that they thought best, not to be bound by instructions from the voters. But again, the rise of parties and changes in practices may make it appropriate to say that under current circumstances, yes, states can instruct to bind. Okay, so maybe you can do it. The third problem is the tension that might arise in the following case. Massachusetts, I believe, actually has joined the compact. Suppose the compact goes into effect in 2024. So Massachusetts voters vote for the Democratic candidate. The national popular vote is won by the Republican candidate, but it's a close in the Electoral College. So if Massachusetts' electors voted for the Democrat, contrary to what the compact says they're supposed to do, they could elect a Democrat. The pressure on them to do that would be extremely strong. And so, although in sort of easy cases, the 2000 election, the 2016 election, 2020 election, 2016 election, you'd get straightforward outcomes, maybe. There are going to be hard cases under the national popular vote approach. I should say also that one thing that people don't think about all that, don't talk about all that much, is that candidates' strategies are affected by the rules that they're operating under. And so if the National Popular Vote Initiative goes into effect, campaigning strategies will differ, will change. It will matter, just to take the easy examples, it will matter to the Republican candidate how many votes he gets in California and New York. And now it doesn't matter because they're not going to get any, not going to get any of the electoral votes. So they don't campaign. And similarly for the Democratic candidate in Texas or some other deep red state. And so we don't really know. We can't project, we can't say if this had been in effect in 2000, Al Gore would have been president or Hillary Clinton in 2016, because the campaigning strategies would have changed.
All right, we've got another question from our YouTube viewers. Franklin thought that if we wrote down our rights, some would say that those are the only rights we have, hence the Ninth Amendment. Isn't it disingenuous for them to support curtailing rights not enumerated?
So this is a question about the Ninth Amendment, which says the enumeration of rights in the Constitution shall not be construed to deny or disparage other rights. There's a strand of constitutional thinking associated with Hugo Black, most particularly, but with a number of other people who say the only rights courts can enforce are the rights that are listed in the Constitution, the first 8 in the Bill of Rights, and a number that are scattered in the original Constitution. The right to be protected against ex post facto laws is in the original Constitution. And they say, Judge Bork said, I don't know what the Ninth Amendment means. It's as if, as he put it, there's an ink blot over the words of the amendment. And so I can't interpret those words. I'm an originalist. I can't interpret those words because I can't figure out what they mean. And in particular, the challengers say, well, maybe there are unenumerated rights, but how on earth do you figure out what they are? Isn't it just an exercise in sort of unguided judicial policymaking or discretion to say, this is an unenumerated right that we're protecting and that isn't? My own view is that that approach, the one I've just described, it's hard for us to figure out, actually fits within the term disparaging other rights, not denying, but disparaging other rights. And so I think my own view is that the Ninth Amendment does license some sort of inquiry into rights that aren't listed elsewhere in the Constitution, and that it's a matter for sound, as Justice Souter once put it, judicial judgment to figure out what they are. I don't have views about what that sound judicial judgment would lead to, except that my own view is that the enterprise of applying sound judicial judgment to determine what unenumerated rights we have, that enterprise doesn't necessarily have a political tilt to it. It's not necessarily liberal or conservative, or maybe it's both. Some rights will be conservative-like rights, some rights will be liberal-like rights. But I think the Constitution says that that's what judges are supposed to do.
All right, I think unfortunately we only have time for this last question, but I think it's a pretty good one. 1776 portrays the conservatives at the time as pro-crown, while the liberals were pro-revolution. Famously, Nixon hated this characterization. Is this an oversimplification of the reality of the time?
So the question is that the play musical depicts, in modern terms, the people supporting the crown against independence as analogs to contemporary conservatives, and the people favoring independence as analogs to contemporary liberals. And the observation was that Richard Nixon thought that was a terrible description of the historical reality. I have to say, I'm a student of the Constitution, not of the Declaration, and I don't know a great deal about it, but I am convinced that it's very bad practice to draw analogies between the politics of 1776 and the politics of some significantly later period. And one way of capturing that is Richard Nixon's conservatism is very different from contemporary conservatism. And so if he was upset because he was saying they were depicting the pro-royalists as conservatives like me, that doesn't mean that he would be upset at depicting the pro-royalists as conservatives like Mitch McConnell. I mean, maybe he would, maybe he wouldn't, but we don't know. It's just, the world, the ideological world changed so dramatically. Not only between 1776 and 1968, but between 1968 and today, that these kinds of analogies are very tricky to draw. Maybe that's a criticism of the play. That is, maybe the depiction in the play does elicit in viewers this sense of conservatives pro-crown, liberals pro-independence. But it's probably worth saying, go see the play and think about it for yourself. Okay, so thank you for joining this evening and for those thoughtful questions. I enjoyed connecting with you all, and on behalf of myself and the ART, I want to thank you for joining us for the very first fully digital Salon as part of the 1776 Salon series. And have a good night, and I hope to see you at the theater soon.